Hello, welcome to Law at Ease, your safe space to understand the law clearly, calmly, and confidently. I am Advocate Nandini Jaiswal. Welcome to Season 1, Episode 4, where we get into the minimum standards concept in intellectual property rights under the WTO. So let's get started on our journey from legalese to ease. In the previous episodes, we explored the non-discrimination principles that run through the WTO framework, principles like national treatment and most favored nation, which ensure equality in how countries treat foreign goods, services, and intellectual property. These principles act as a harmonizing thread across international trade law. Article 1.1 of the TRIPS Agreement clarifies that although members must comply with these obligations, they are free to decide how to implement them within their domestic legal systems. This allows countries, particularly developing and least developed nations, to tailor their IP laws to their own socio-economic and technological needs. This brings us to an important yet less talked about concept, minimum standards of protection under the TRIPS Agreement. We were told how we are meant to give equal treatment to member countries. However, did we address what if equality is not the same for everyone? What if one country offers weak protection under its own domestic regime and extends that same weak protection to others, claiming equality? Will a strong IP protecting nation accept another nation's weaker IP just because they say, "We are treating you like we treat our own"? This is what the minimum standards answer. The agreement provides a baseline level of intellectual property protection that every WTO member is obligated to provide, below which no domestic legal system can fall. These minimum standards are primarily contained in Part 2 of TRIPS, with Part 3 ensuring their enforcement. Together, they define what must be protected, how it must be protected, and how those rights must be enforced. Minimum standards reflect three important features. First, substantive rights. They define the essential rights that must be granted to IP holders. Second, flexibility in implementation. Countries are free to determine how they implement these obligations within their domestic legal systems. And third, no ceiling TRIPS plus possibility. Countries are free to provide higher levels of protection than what TRIPS requires. So, what must be protected? Substantive minimum standards answer one basic question. What kind of intellectual property protection every country must have in its law? It requires countries to protect all major forms of IP, copyright, trademarks, patents, geographical indications, industrial designs, trade secrets, and layout designs of integrated circuits. Countries cannot excuse themselves from recognizing any of these categories of intellectual property. It also ensures that protection is available broadly and without discrimination, especially in patents, where protection must be granted across all fields of technology. However, TRIPS does allow certain limited exclusions, such as diagnostic, therapeutic, and surgical methods, as well as plants and animals, subject to specific conditions. Apart from setting categories, it also lays down the nature of rights that countries must acknowledge and provide. For example, authors must have control over reproduction and communication of their work. Trademark owners must be able to prevent confusing use. Patent holders must be able to stop others from making or selling their invention. TRIPS also fixes a minimum duration of protection, so countries cannot reduce protection below a globally accepted baseline. Minimum standards are about structured and balanced protection. Countries may include limited exceptions, regulate misuse of IP rights, address anti-competitive practices. Let's have a quick look at specific standards. Copyright law incorporates substantive provisions of the Berne Convention, except moral rights, requiring protection of literary and artistic works, with rights such as reproduction and communication to the public, and a minimum term of life plus 50 years. Trademarks require protection of any distinctive sign capable of distinguishing goods or services, grants exclusive rights to prevent confusing use, and mandates protection of well-known marks in line with the Paris Convention. TRIPS requires a minimum term of 7 years for trademark registration, with the possibility of indefinite renewal. Patents must be available for inventions in all fields of technology, subject to novelty, inventive step, and industrial applicability, with a minimum term of 20 years. TRIPS goes beyond recognition of rights. It requires effective enforcement. Countries must provide civil remedies, injunctions, damages, border measures, criminal procedures in cases like counterfeiting and piracy. This ensures that rights are not merely theoretical but practically enforceable. In line with enforceability, TRIPS allows flexibilities. Minimum standards are meant to act as a foundation and not be rigid. Interestingly, if you look for a chapter titled Flexibilities in TRIPS, you won't find one. That is because flexibilities are not grouped together. They are woven into the agreement itself. Let's briefly understand how. One of the most powerful flexibility is compulsory licensing under Article 31 of the agreement. This allows the government to permit the use of a patented invention without the consent of the patent holder under specific conditions. For instance, public health crisis, or when a drug is priced so high that it becomes inaccessible. India did use this flexibility in Bayer Corporation v Natco Pharma Limited, allowing manufacture of a much cheaper generic version of a heavily priced cancer drug. This significantly reduced the cost of the drug, improving accessibility. Then there are exceptions and limitations, where use is permitted without permission, such as in copyright cases of fair dealing for education, research, criticism, or reporting. In patent law too, there are exceptions for use of a patented invention for research purposes, for obtaining regulatory approval, like testing a generic drug before patent expiry. One such exception is the Bolar exception, which ensures that generic medicines can enter the market immediately after patent expiry without unnecessary delay. However, Bolar exception too has limitations. It does not allow for commercial stockpiling or selling of the product while the patent is still in force. Under the Indian Patents Act, the Bolar exception is codified under Section 107A. This allows for experimentation and even export of patented products for obtaining regulatory approvals. Another important provision is that of the exhaustion of rights, which is about controlling the afterlife of IP. Once an IP holder has lawfully sold a product in the market, their control over that product is considered exhausted, opening the possibility of parallel imports, meaning a country may import genuine products from another country where they are sold more cheaply. This directly impacts price access and market competition. India follows the principle of international exhaustion, as clarified in Kapil Wadhwa v Samsung Electronics. Now, this is a nuanced concept that raises more questions than it answers. When can a product be considered exhausted? What determines a lawful sale? And whether a country follows domestic exhaustion or international exhaustion. Let's keep the detailed discussion on exhaustion for some other day. For now, let's just note it as an exception and limitation under the TRIPS agreement and move on to the Doha Declaration on TRIPS and Public Health, which was a response to concerns that intellectual property rules were hindering access to essential medicines in developing countries. The declaration clarified that public interest considerations are integral to the TRIPS framework and that the agreement should be interpreted in a way that supports public health and access to medicines It reaffirmed the right of countries to use flexibilities such as parallel imports and compulsory licenses, and that countries have freedom to determine the grounds for granting compulsory licenses and to define national emergencies independently. While we talk of the declaration being adopted from the perspective of developing nations' concerns over IP, we may well look into India's stance on TRIPS. India's approach demonstrates both compliance with and strategic use of TRIPS minimum standards and flexibilities. In copyright law, India exceeds the minimum standard by providing a term of protection of life of the author plus 60 years and recognizing additional rights such as moral rights and performers' rights. In trademark law, India again goes beyond TRIPS minimum standards by providing a 10-year renewable term, recognizing well-known trademarks, service marks, and expanded doctrines such as trans-border reputation and dilution. In patent law, India complies with the 20-year term requirement but adopts a calibrated approach through provisions such as Section 3D of the Patents Act, which restricts patentability of new forms of known substances unless they demonstrate enhanced efficacy, thereby preventing evergreening. India also incorporates compulsory licensing provisions, recognizes parallel imports, and provides statutory exceptions for research and educational use, thereby actively utilizing TRIPS flexibilities. With India's approach to minimum standards, flexibilities, and TRIPS plus standards, we come to the end of this episode. So, what do we take away from minimum standards? That they set the baseline level of protection, defining the rights that must exist, the minimum duration of those rights, and the space within which countries can shape their laws around their own domestic priorities while still meeting international obligations. Essentially, they mark the starting point, the legal floor below which protection cannot fall. That's all for today. Thank you for listening to Law at Ease, where we take you from legalese to ease. If the law felt complicated before, I hope it feels a little clearer now. Till next time, keep the law simple.